Gresser v. Hotzler is a contract case that comes to us from the state of Minnesota, and specifically the Minnesota Court of Appeals, so the Minnesota Intermediate Court, and it is decided in the year 2000. And this case is about a rule in contract law known as the mirror image rule. So let's go ahead and dig into the facts of this case. And so we have the two parties, Gresser and Hoztler. And the basic fact is that Gresser is trying to buy a house from Hoztler. And so Gresser sends over to Hoztler a contract. And this contract has several terms. Let me get some more space here. So this contract has several terms that are written down. And then at the bottom, there are two places for each party to sign the contract. And so Gresser delivers this contract to buy Hotzler's property, and all of these terms are there for Hotzler's review. And Hoztler ends up reviewing the contract, and he makes a couple changes to some of the provisions. And on each provision, he initials the change. And then at the bottom, he signs it. And then he sends it back for Gresser to review the changes. And so Gresser reviews the changes. He is in agreement with all of the changes that Hoztler makes. He initials those paragraphs as well, and he ends up making one final change, which is just for the date of basically when the contract's going to be executed. And he initials this change, and then he signs it, and then he sends it back again to Hoztler. Okay, so this contract is initiated. Gresser sends the unsigned contract to Hoztler. Hoztler makes some changes, signs it, sends it back to Gresser. Gresser ratifies the changes and makes one final change, which is just the date that the contract's going to be executed. He sends it back over to Hoztler, and he also signs the bottom. And Hoztler, when he receives this contract, puts it on the kitchen counter and forgets about it, and he never ends up initialing this final change that Gresser makes to the contract, which again is just dealing with the date that the contract is going to be executed. Now, as fate would have it, as this contract with Gresser is sitting on Hoztler's kitchen countertop, Hoztler receives another offer from another buyer, and that contract he also puts on his kitchen countertop. And so on his countertop, he has Gresser's contract. And then he also has another contract from a third party. And this other contract offer that Hoztler gets sent ends up being a better deal than the one that he had negotiated with Gresser. And so Hoztler ends up going forward with this other contract and sort of leaves Gresser sitting out in the cold while Hoztler goes forward with this other buyer for his property. And of course, Gresser ends up suing Hoztler, arguing that they had a contract, both parties had signed it, and Hoztler was in breach of the contract by trying to selling the property to a third party. So the court assesses this contract under, as we mentioned, the mirror image rule. And what the mirror image rule basically says is that for a contract to form, there must be a meeting of the minds. And so this is another way of stating the mirror image rule, that core element of a contract of mutual assent means that there needs to be a meeting of the minds, which means that when an offer is made to someone, the only way for a contract to form is for the person who's receiving the offer to accept unconditionally the offer that's been made to them. So there must be unconditional acceptance. And the court ends up holding that when Gresser sent the contract back to Hotzler the second time and had this provision, which again, it was only the date that the contract was going to be executed, and there was no initial from Hotzler. No initial from Hotzler, which means that there was not an unconditional acceptance of the contract. There was no meeting of the minds, because this final provision, which Gresser had changed in the contract and sent back to Hotzler, Hotzler had never agreed to that final change in the contract. And so there was no meeting of the minds at any point in the contract. Both times that the contract was sent back and forth, even though each party signed it, there were changes in the original provisions. And in order to form a contract, both parties need to be in agreement on all of the changes. And this final change that Gresser made, even though Gresser agreed to it, Hotzler hadn't signed off on that, which meant that there was no contract that was ever formed between Gresser and Hotzler. And so Hotzler, when he got the better offer from that third party, he was free to accept it and leave Gresser out in the cold. Now, Gresser's argument to the Court of Appeals was that his revision, this final revision about the date of execution, that was actually he argues that that was actually just a request for modification. So Gresser argued that when Hotzler sent back the contract that had the few provisions that were changed, Gresser had unconditionally accepted those revisions and signed. He had signed. He had initialed Hotzler's changes. He had signed it. He had unconditionally accepted the contract that Hotzler had sent back to him with these changes. And this final change that Gresser made was just a request for modification that did not affect what Gresser said was an unconditional acceptance of Hotzler's proposal. So Gresser argued that he accepted the contract as amended by Hoztler, and that this final revision was just a request for modification. And Gresser argued that, again, the final change that he made was just about the date of execution. But Gresser asserted that he would have accepted Hotzler's proposal even absent this final change, and that all this was just a request to change an immaterial term just to make the transaction go more smoothly. So this request for modification, he argued, was immaterial in that it wouldn't have affected whether or not Hotzler agreed to this change, would not have affected whether Gresser was willing to go forward with the deal. He just wanted a new date for the execution just to make it easier. And so that was a request for modification, not a counter offer, as the case may be. The Court of Appeals doesn't buy Gresser's argument. And the Court of Appeals basically holds that by crossing out this paragraph, writing a new one, initialing it, that indicated that this was a material provision of the contract. The Gresser was not merely just requesting a modification of a contract that he unconditionally accepted, and that Hotzler had no reason to believe that Gresser had accepted the contract at this point, since he had made a change to one of the provisions. So this case tells us a couple of things with regard to the law of contracts at common law. So at common law, when we are talking about the formation of contracts, so contract formation, there are only, when we're talking about contract formation, there are only 4 actions that really matter for contract formation. So you have an offer, you have acceptance, you have rejection, and you have revocation. Okay? So contract formation always starts with someone making an offer, and a contract can only form once someone has accepted the offer, and a contract doesn't get formed if the offer is rejected or if the offer is revoked before it's accepted. So these are sort of the 4 buckets that you get when we're talking about common law contract formation. So one of the issues that comes up with contract formation is how to deal with this thing called a counteroffer. And so that's what happened with Gresser and Hoztler, is Gresser essentially sent a counteroffer to Hoztler. And common law, notice we don't have a bucket for counteroffers when we're talking about common law contract formation. So we only have these four buckets. A counteroffer does not fit neatly into any of these buckets. And common law says that when someone makes a counteroffer, what a counteroffer is a rejection of the original offer a rejection of the original offer plus a new offer. So when at common law, when you get sent an offer and you make a counter offer, even if it's just changing small details of the contract, say both parties are in, 95% agreement about what the terms of the contract are, but they're still negotiating over that 5%. When you make a counter offer, it is a 100% rejection of the original offer, and it is considered a 100% creation of a brand new contract. So common law does not consider a counteroffer to be its own independent concept. In common law, when you send a counteroffer, that is a rejection of the original offer, and it is a proposal for a brand new contract offer that is being sent. There is no sort of carryover between the original offer and the new offer. Okay, now that differs from how people typically approach contract negotiations when they're making counter offers. It's sort of an implied agreement as to all of the other provisions of the contract with just an agreement to renegotiate a couple provisions. But the way that the common law sort of looks at this is that even if the parties are in, agreement over 95% of the contract, that 5% that they're not in agreement over might be important to one of the parties and might be material for them as to whether or not they want to form a contract. And so even though they're in 95% agreement, that 5% common law assumes that will be fatal to the formation of a contract if both parties don't agree. So the only way to get the formation of a contract in common law is for there to be an acceptance of 100% of the contract. If it's 95% of the contract, that is a rejection of the contract. So if you make a counteroffer under the common law, that means that you are rejecting the offer. Now, in reading Gresser v. Hotzler and the common law mirror image rule, you may have found yourself feeling like this wasn't a just outcome. Because after all, the only change that Gresser made to the contract was just the date to which it was going to be executed. And it's not apparent from the facts that that was actually something that Hotzler cared about. Hotzler was just sort of waiting around to see if he could get a better offer, and when he did, he just turned around and accepted that better offer and left Gresser out in the cold. So, um, you might feel like that was an unjust result, and that sort of gives you a preview of how the law might have approached this situation differently. So, at common law, we have this mirror image rule. And you'll note that this mirror image rule, is strict, and it prevents contract formation. And so you might think to yourself about ways in which the common law rule could be, modified to not be to be a little bit more flexible and to save these sort of contracts that are negotiated where there is, where there is agreement as to all of the material terms, and there's just some ongoing negotiation about minor provisions in the contract. And that sort of gives you a preview for what is a different approach that's taken by the Uniform Commercial Code, the UCC, because the UCC did not adopt the common law mirror image rule, and instead has its own approach to dealing with counteroffers, where counteroffers can be in their own bucket. And this UCC rule is known as the Battle of the Forms. And this Battle of the Forms rule provides a more flexible approach to the formation of contracts that ultimately encourages contract formation. And this allows sort of what we would think of as immaterial counteroffers. This allows immaterial counteroffers to mature into acceptances. And so this maturation of a counteroffer is what underpins the rule of the Battle of the Forms. And so the approach of the Battle of the Forms is basically when you make an immaterial counteroffer where you accept all of the material terms but make some changes about immaterial provisions, such as the date in which the contract will be executed. The Battle of the Forms is essentially a rule that has us look towards who made those changes and whether or not those changes will take effect, or whether the person that made the counteroffer is going to be bound by the original provisions of the original offer. So that sort of gives you a preview for how the Uniform Commercial Code differs from the common law. And remember that the Uniform Commercial Code is governing contracts for the sale of goods, which is sometimes just referred to as sales. So contracts for the sales of good are governed by the Uniform Commercial Code, which does not follow the mirror image rule and has its own approach called the Battle of the Forms.